They told me I couldn't have my lawyer on this. They said, having Alex Spiro, yes, my Alex Spiro, on my defense team in the shareholder lawsuit over the 2022 X acquisition was somehow a problem. They argued Spiro might be called as a witness, that jurors could get confused, that it would be unfair, but I wasn't letting go of him. Not now, not ever. Spiro has been in my corner for years through fights, lawsuits, complex deals. I trust him, and I told the court I would only accept his representation, and I signed written consent saying so. The plaintiffs filed objections, claiming Spiro's dual role, lawyer and potential witness, could prejudice the jury. They said his involvement in the lead-up to the X acquisition and all the messy negotiations meant he might be better as a witness than as counsel. They asked the judge to disqualify him. I understood the move. A classic last-minute tactic, thrown in the hope of derailing my legal strategy and maybe forcing delays. But, to their surprise, the judge didn't bite. Judge Charles R. Breuer reviewed the objections and ruled in my favor. The court concluded that my choice of counsel, the lawyer I trust, outweighed the generalized risk that jurors might be confused. The plaintiffs hadn't shown any specific harm. There was consent. And, importantly, there were alternative ways to present testimony if Spiro does end up on the stand. So, Alex Spiro stays. Now I'm left thinking this was never really about fairness. It was about disruption. They wanted to shake up my defense team, mess up our rhythm, maybe force new counsel, waste time. But that gamut failed. Spiro remains at the table. The defense stays whole. I'm not naive. The lawsuit, Pempina v. Elon Musk, accuses me of misleading investors, playing with stock price, trying to renegotiate or even back out of the deal, using social media posts and public statements to manipulate the narrative around the $44 billion takeover. They call it market manipulation, stock price, tampering, investor harm. I call it business. I reject the claims. I've always believed I acted in good faith. I believe in free markets, in bold moves, in transparency to the extent legally required. Now the path ahead is clear. I have my trusted lawyer, my legal strategy intact, and I'm prepared to defend, not just for me, but for the principle that entrepreneurs should be allowed to make hard decisions without being railroaded by last-minute legal ambushes. Let them bring their case. We're ready. After the ruling came down, I walked out of the building feeling something I don't often feel in these situations. A kind of calm, the quiet confidence that comes when the universe reminds you that logic still wins sometimes, because throughout this whole process, the noise around the case kept getting louder. Analysts speculating, commentators dissecting every move, everyone pretending they know what I was thinking back in 2022 during the X acquisition, when in reality, very few people understand what it's like to make a decision that impacts an entire global communication system while dealing with markets that react instantly, emotionally, irrationally, and yet I'm the one accused of destabilizing things, as though the market isn't a chaos engine all on its own. And now, as I prepare for what comes next, I can't help replaying that acquisition period in my mind, remembering how every action was magnified, how every tweet was treated like a seismic event, how every conversation was interpreted like some encrypted message about my intentions, when half the time I was literally just thinking out loud, which I've always done publicly, for better or worse. because that's how I operate, openly, iteratively, transparently, whether people like it or not. And the plaintiffs keep insisting I manipulated the stock price, that everything I did was some elaborate scheme, when the truth is that the deal itself was the point. The transformation of Twitter into X, the shift from a constrained platform into something capable of being a global marketplace of ideas and services and communications. And I knew the transition wouldn't be clean or quiet, but I didn't expect this many retroactive accusations about motives, as though intent can be reconstructed by people who weren't in the room, who didn't see the internal chaos of the old platform, who didn't feel the urgency of preventing an essential part of the public conversation from collapsing under a bureaucratic bloat. And that's part of why keeping Spiro on the team matters so much. Because he understands not just the legal architecture of what happened, but the human architecture, the psychology, the pace, the polarity around everything I do. And as I think ahead to trial strategy while reviewing documents, messages, meeting notes, I'm reminded how many people predicted the acquisition wouldn't even happen, that I'd walk away, that it was some kind of elaborate bluff. And yet here we are, years later, still litigating what the acquisition meant, still fighting about what I said, when the reality is that the platform exists, it evolved, it functions, and frankly, it's stronger than the version I bought, because chaos is merely part of the growth cycle. And as I continue preparing with Spiro and the rest of the team, I'm ready for the plaintiffs to dig into every message, every email, every conversation, because none of this intimidates me. If anything, it sharpens my focus. And this latest ruling, the judge letting Spiro stay, reinforces that we're moving forward with exactly the team we need. And when you've built rockets, cars, AI systems, and social platforms under nonstop scrutiny, a lawsuit, even a high-profile one, becomes just another engineering challenge, another system to understand and navigate. And that's exactly what I intend to do: navigate it, dismantle it, and prove once again that people can project whatever narratives they want onto me, but the facts remain the facts, and the truth has a way of rising through the noise, and eventually everyone will see that. As the days move closer to the next phase of the lawsuit, I find myself thinking less about the noise around the case and more about the architecture of the entire situation, almost like I'm standing above a blueprint of interconnected systems, each piece influencing the next. Because that's how my mind works when pressure builds. I start treating everything like a solvable engineering problem, even a lawsuit. And while the plaintiffs keep trying to reinterpret every decision I made during the X acquisition as some elaborate conspiracy, I can almost see the patterns behind their strategy. Push confusion, question motives, disrupt momentum, and hope something sticks long enough to make the narrative look credible. But I've been through enough public battles to know that narratives built on speculation eventually collapse under their own weight. And every time I meet with Spiro in those late night sessions where the room is scattered with notes, timelines, charts, he keeps reminding me that the strongest defense is clarity, not noise, which is why we've been dissecting every claim, every allegation, every hypothetical scenario they have tried to construct, stripping them down to the structural reality underneath. And honestly, there's something strangely energizing about that process, the same feeling I get when I'm troubleshooting a rocket anomaly or debugging a neural network timing issue. Because once you understand the problem at its root, the fear disappears, and all that's left is focus. And even though I know the trial will be intense, with cameras outside the courthouse, commentators analyzing my facial expressions, investors watching like it's some kind of gladiator match, I've realized that this entire saga is also a test of something bigger. Whether vision-driven decisions can withstand the gravitational pull of hindsight criticism. And the answer, at least in my mind, is yes, absolutely yes, because everything I did around the acquisition, every moment of uncertainty, every recalculation, every public comment came from a place of trying to build something that could actually matter on a global scale. And people can misinterpret that if they want to. They can assign motive, attach meaning, create shadows where there weren't any, but that doesn't change the core trajectory of my intent. And now as I prepare for what's coming next, I feel an odd sense of inevitability. Like this lawsuit is just another stage in the evolution of the platform, another stress test, another ignition sequence that has to fire before the next phase begins. And with Spiro still on the team, with the ruling behind these, I'm moving forward with the same stubborn determination I've relied on for years. The same mindset that took Tesla from survival mode to global scale. The same resolve that landed boosters upright when everyone said it was impossible. And if there's one thing I've learned, it's that the universe rewards persistence far more than perfection, which is why I'm ready for the next hearing, the next argument, the next round. Because whatever they throw at me, I'll meet it head on. And I won't back down, not now, not after everything that's already happened, not when the bigger mission is still